Good evening and good to have you with us in the 8 p.m. edition of the Urban Debate. Viewers, a few months back, the biggest story in the country was the Pegasus row. After a bunch of international news organizations, along with The Wire from India, reported on how there was a target list of names of individuals from various walks of life, big names in politics, ministers, lawyers, judges, journalists, whose names were on this target list supposedly for carrying out surveillance. And they linked it to the Pegasus software, Pegasus spyware, by the company that claims that they only sell it to governments. Now, repeatedly it's been said it is unclear who owns it in our country and is using to spy on the citizens. But we here at Mirror Now repeatedly said that we must find out. We repeatedly said that if there is a possibility that somebody is spying on citizens of this country, then it is the duty of the government to duly investigate what is going on. We repeatedly said that the right to privacy must be safeguarded for the citizens by the government itself, and that the central government needs to take the lead rather than leaving it to individuals running around with various police stations seeking some kind of a recourse. We had repeatedly asked, why is it that we are not getting clear answers from the government on the use of Pegasus, on what was the extent of their own, if any, investigation they did into the use of Pegasus, either by any government institution or by a private entity, into the lives of people. That debate then reached the Supreme Court. And the Supreme Court today has appointed a committee comprising 3 technical members, supervised by retired Judge Justice Ravindran, to conduct a thorough inquiry into the allegations of the use of Pegasus software for unauthorized surveillance. That's what it seems, unless somebody admits that it was all authorized. The 46-page order, the court has made several important observations on the issues exactly that we kept raising. Freedom of press, right to privacy, 2 key focal points in this order that was given today and the observations that were made by the Supreme Court of India. For example, the top court says that the press freedom is an important pillar of democracy, that surveillance may undermine the ability of the press. Snooping may result in self-censorship. This is a very important point that the top court of our country is making. Snooping may result in self-censorship. Such kind of a chilling effect, assault on press, is not okay. Snooping may have a chilling effect on press freedom. I don't think it could have been said any more clearly. And it is the responsibility of institutions like the judiciary and the executive to safeguard this press freedom rather than enabling an environment in any manner that has such a chilling effect. On right to privacy, the court said it is important to safeguard it. Privacy is important for all citizens. Because there was a narrative that, it's only for a bunch of people, it is only for a handful of journalists and maybe some politicians. The court says, well, we're not just concerned about the journalists, but right to privacy is important for all citizens. That the use of surveillance has to be evidence-based. So yes, the Supreme Court is cognizant of the fact that when it comes to matters of national security and battling terrorism, some amount of surveillance may be required. But that has to be evidence-based. Indiscriminate spying cannot be allowed, says the top court. Our entire lives are now stored in a digital dossier, and it is incumbent on the government to consider the use of such a technology. It is the duty of the government, in a sense, to keep in mind when such a technology is being used. These are the top points that have come across by the Supreme Court. And we told you why it is so important for an investigation, a fair investigation, to be done, for the truth to come out. We never at any point speculated on what the truth is. Nobody is saying that the government is snooping on its citizens because we don't have the evidence. But whether it's the government of India, of China, or some country in Middle East, or any other country, or if it's a private entity, an international corporate, a domestic corporate, we don't know. So why should we not know? Why should we not find out? So that's the big question. And does this order now completely take apart, destroy the argument presented by the government that it's a matter of national security, so we cannot really talk about this? N.S. Napinai, advocate with the Supreme Court, a cyber law expert, joins me this evening. Ramanjeet Singh Chima, Senior International Counsel and Asia Pacific Policy Director at Access Now. Aman Panwar, spokesperson for the Congress Party. Bishrudi Bhattacharya, former ASG. Geeta Luthra, Senior Advocate with the Supreme Court. Raman Malik of the BJP joins me this evening as well. Thank you so much to all of you for joining me. Mr. Chima, let me start off with you. Several of the points that we exhaustively discussed have been addressed in this. Which one is the most important to you? Your biggest takeaway from what the Supreme Court said today?
I think the most important thing to take away from this judgment is the fact that the Supreme Court has said that the government owes answers to the people, and it's failed to take a clear stand on this situation. It's failed to provide clear answers regarding what's the allegations made around its use of the Pegasus hacking suite of the sort of vulnerabilities that people have come under, and they fail to demonstrate true independence and autonomy on answering these questions. And the court has said very categorically, if you had even done and taken some of those steps, we may not have stepped in, but we have to step in because you are making extraordinary claims around national security and providing no information around what you're doing. And you seem to be operating under the sort of basis where you think the Constitution doesn't apply, and the Constitution does apply here. And I think is ultimately striking that the court was so clear and explicit in its language around its disappointment in the position taken by the union government, or the absence of a position, the absence of information, and the absence of cooperation with the top constitutional court that this current government has shown, unfortunately.
Yes, that's a very important point that you have highlighted right now. Let me take it across to N.S. Napinai and get her view as well. Your key takeaways, the message that the Supreme Court is sending, and the point that was made about to what extent should Supreme Court enter such segments where national security becomes a matter, and the court justifying why they really had to.
Tanvi, you may not recollect that we had this conversation a long time back,
yes,
where somebody contested in your panel about, national security taking primacy over privacy. And here you have a Supreme Court judgment which very categorically clarifies on this point. And if you recollect, I had also batted very strongly for privacy at that time. So this is my takeaway. And in fact, I had literally predicted where it is going to go in my article on 14th of September, when just after the whole issue about the absence of a detailed affidavit came up before the Supreme Court. Now, this is where we stand. One, that the government needed to investigate this issue or start an inquiry was a given from the time when this issue started. It could have done it, it didn't do it. Two, with this case coming up before the court, the issue was about, did anything really happen, or is it just accusations? Irrespective of where it stood, again, it needed an investigation or inquiry. Therefore, a committee looking into it, be it that which a government would have appointed or where now, given the circumstance, the Supreme Court had to appoint, was a given. Where is it headed? One, the fact that privacy cannot be brushed aside merely by quoting national security has become an important point that the Supreme Court has emphasized. Two, where do we stand in terms of privacy, and what is the importance for government agencies to follow established checks and balances is actually going to become the focus going forward. Because you look at it from an Information Technology Act perspective or the Indian Telegraphs Act perspective, neither permit for the use of a spyware for surveillance, even where surveillance is authorized as per due process. What they allow for is for you to take the assistance of the service provider or the platform for completing the process of surveillance, which again has checks and balances in terms of reasonable costs and the requirement to be evaluated and reviewed through a review committee. So today, we do have surveillance that is built into the reasonable exceptions in terms of fundamental rights, but there is a very clearly set out procedure which you are expected to follow. Today, where we stand is the committee will have to come out with an evaluation of whether these processes have in any manner been violated, and the consequences, if the committee were to find out so, would be very serious.
Okay, you're absolutely right. And I want to take that point across to Mr. Raman Malik, because Mr. Raman Malik, at the end of the day, what the court here is saying that, one, the argument of national security cannot apply everywhere. You need to do it on an evidence base. And secondly, what we've gone in details often, that spywares like Pegasus do a very different job than what a legitimate surveillance would be, where, you know, following a proper process, you get permission, you carry out surveillance over a phone, you tap it to see what calls, and you end it basis a certain date once your job is done. A spyware like Pegasus gets inside your phone and in every part of your life, therefore, and then just stays there. And that is the other problem. Do you now admit that these are some things that the government by itself could have looked at without waiting for the Supreme Court?
Tanvi, I think your research team would have definitely read the affidavit given by the Government of India on the 16th of August 2021. And it very clearly welcomes, and we very clearly in the morning also on your channel, I welcome the move of this Honorable Supreme Court. Reason being that we are not those people who question the Supreme Court intent and execution every time. You know, there are a lot of decisions which the Supreme Court has done, and a lot of people who so-called come over to your channel and have the the gown of legitimacy of freedom of expression and other such adjectives that they use, they generally tend to question the Honorable Supreme Court in any and every manner, whether it was Ram Janmabhoomi, even to the extent the very so-called farmer agitation and the people supporting it have questioned the Supreme Court, and even to the extent that they've said that the Honorable Supreme Court is working on the directives of the Government of India.
Okay, but Mr. Malik, sorry, I didn't understand.
Can I come in? Let me put
1 minute, please. Sorry, I didn't understand. Not only is my research team, but I too have read the affidavit that was given by the government's response effectively to the court, which was essentially to say, well, we can't really tell you much because it's a matter of national security, and that's where they left it. The Supreme Court itself, Mr. Raman Malik, has said that we are having to give this order. 1 minute, please. 1 minute, please. 1 minute. Allow me to finish my point. Allow me, gentlemen, to finish my point. The Supreme Court itself in the order has said that we are having to intervene and give this order because the government's response was extremely vague. The Supreme Court has said the government response was vague on this issue. The government, Mr. Malik, could not convince the Supreme Court why it was a matter of such national security that they wouldn't even tell the Supreme Court, that they won't even do an investigation, that they won't admit anything, talk about anything at all. The government's arguments about national security, that the use of software is not a matter of public discussion, that filing an affidavit will be detrimental to national security, issues like spyware cannot be debated on affidavit, don't want to put in public domain whether Pegasus was used, was an answer that left the Supreme Court wanting for more. and
Okay,
hence
so
this
can I
committee. Just clarifying it. Now you can continue, please. Yes, Mr. Malik. I must also say good evening to Raghav Avasthi. I missed introducing him at the beginning. I also have Mr. Sapul joining us for the Congress party. But first, Raman Malik can complete his point.
Okay, so thank you for interjecting in between and breaking the flow of my answer. But anyway, let me conclude, not conclude, but let me continue from where I was stopped. In the evening today, the national spokesperson, Mr. Sambit Patra, had very clearly given a press brief where he said, and I'm quoting that the affidavit contains this very fact that the government was of the opinion that an expert committee could be looking into it. There was another statement very correctly made that you must come out, truth must come out. I have no problem in it. But the fact is, the same people, the same bunch of people have never bothered to ask the question on the legitimacy of the comment given by the then Home Minister, Mr. Chidambaram, about 2,300 odd people being spied upon or being looked into, which included the then Congress leader, Mr. Pranab Mukherjee, who went on to become the President of India. But the point here is, yes, national security, when it comes to it, it is paramount, no issues on that. But at the same time, we must also not forget that the Supreme Court decision is welcomed by us. Had there been anything that we would have to hide, we would not have been here welcoming it.
Okay.
There are people who are always questioning the Supreme Court.
But,
So
Mr.
my
Malik,
interjection,
you tried your best to block it, to deny it, to dismiss it, and then when the Supreme Court says, no, nothing doing, we will still investigate, you say we welcome it. So I don't think that really counts for much. Unless you want to take on the Supreme Court and be in contempt, then that's your choice. Everybody has to at least accept what the most supreme judicial entity in our world, in our country has to say, and that is the Supreme Court. I want to bring in two more voices who haven't spoken yet. Mr. Sapul, good evening to you.
In the matter of Rafale also,
Yes.
the same people or the same...
Which people? Why are you attacking other people who are not on the show in response to what I am saying?
No, even your channel had certain lines that it took. At the end of the day, the Supreme Court countered the line that you took in Rafale also. So do not forget that.
I didn't turn around and say suddenly my view has changed and I welcome what the Supreme Court had to say. You are the government. You are responsible for people's privacy. You are responsible for ensuring press freedom. You are the government that is responsible to find out if somebody is spying on its own people. You refuse to do so. You said so in the parliament. Now you can sit here and welcome the Supreme Court's verdict. That doesn't really make any difference to anybody's life. Mr. Sapul, the argument being presented, since you are the other side, is what happened when Chidambaram was spying, what happened when in Congress's time so many cases of spying took place. Please respond to that.
I'll respond to that, but before that I was listening to Mr. Malik, and that reminded me a saying in Hindi, कि फिसल गए तो हर हर गंगे, कि आप फिसल गए हैं तो अब हर हर गंगे कीजिए. The fact remains that today, even while
गंगे का काम राहुल गांधी का साहब, मौसमी हर हर गंगे राहुल गांधी करते.
I did not interrupt you, Malik Saab. You can answer after I speak. Today, Supreme Court, while ordering this inquiry, Tanvi, blew to smithereens the government of India's defense in Pegasus so far. It clearly held government responsible for infringement of fundamental right of privacy and fundamental right of freedom of speech. It also said that government cannot hide behind the fig leaf of national security. And now I'll add to this, it has effectively said that the government of India has actually gone against the national security by using a spyware of weapon grade against the institutions of this country. So let us be very clear, and Mr. Malik was talking about the affidavit. What did the affidavit say that time? It said it makes it clear that the allegations are based on conjectures and surmises and other unsubstantiated media reports or incomplete or uncorroborated material, and nothing further needs to be done. This was the sum and substance of the affidavit. And then by being magnanimous towards the court, they said, okay, we will appoint a committee. we will appoint it. I am reading out of affidavit, Malik Saab. I am reading affidavit is before me. I am reading out of affidavit. So please do not say I'm on record saying this. The government then said we'll appoint a committee, which Supreme Court did not agree to because Supreme Court of India realizes that here the government of India is culprit. One of its agencies has bought this weapon grade spyware, which no private individual can buy. So how can government of India investigate against itself? And that is why the Supreme Court also said that there can be no restriction on the judicial review of any such matter. These are strong words by Supreme Court of India. And whatever will come out of inquiry is a matter of, we will have to wait and see. But what today's Supreme Court said is good enough for this government to actually go. Somebody should be held responsible in this government. If not Prime Minister, then Prime Minister should hold somebody responsible because infringement of fundamental right is what the government has been accused of. Government has been accused of taking a shelter behind a fake slogan of national
Not
security.
at all. Not.
And about
No.
Chidambaram.
No.
Okay.
Congress party never said.
Yes.
Congress party has never said that rightful judicial use of espionage is not part of national security.
Yes.
It is. Issue is whether you are using a weapon to be used against terrorists, against Supreme Court, against the armed forces, against election commission, against union ministers, against state governments, against journalists, against common people. This is the issue.
Yes.
You cannot purchase a weapon and use it upon your own people and institutions. You are blowing away the national security. You are damaging the national security. The espionage.
So the difference, Mr. Suppal, that you're making is that, you know, legitimate as a matter of record surveillance cases, which is what the RTI response actually showed about the UPS tenure, is not what we're, debating here, which is perhaps illegitimate, unabashed use of a spyware to look into the personal lives of citizens. That's the distinction that we have to draw and we have to keep in mind. The court says it is for the reasons above, where they have listed out at least 7 different reasons that we decline the respondent, which is the Union of India's plea to allow them to appoint an expert committee for the purposes of investigating the allegations, as such a course of action would violate the settled judicial principle against bias. Justice must not only be done but also be seen to done. So, Mr. Bishrajit Bhattacharya, clearly there is this very strong view also that if there is a possibility that the Pegasus was being used by the government, how can we allow the government to investigate that?
And in fact, you have hit the bullseye that the Supreme Court today declined emphatically to the Government of India's request to constitute a committee. Supreme Court has also declined to enter into any political thicket. This judgment, which the Supreme Court has interim order has sort of pronounced today, will go down in the history of India as one of the finest judgments. And I say this at the twilight of my 6th innings as a lawyer. I have never seen such an erudite judgment. This judgment is a must read for 1.4 billion Indians and 8 billion humanity at large, the world across, as to how the apex judiciary in a democratic sovereign republic can rise to the occasion and to protect the right to privacy and fundamental right enshrined not only in the Constitution of India, but this is the most cherished dream of the humanity. What the Supreme Court has done, Tanvi, you must remember, it has only tried to arrive at the fact. And what is that fact? Whether there has been any encroachment on the right to privacy, which a 9-judge bench in a unanimous judgment of the Supreme Court on 24th of August 2017 has held to be an integral part of the fundamental right of the Constitution of India, the
Yes.
basic structure of the Constitution. You see, Tanvi, you must remember one thing for the benefit of the audience. By your most illuminating and independent, channel, that what Supreme Court has done today is only an effort to arrive at the truth. It has conferred unfettered power on a 3-member committee to arrive at the truth.
Yes.
You read the para 62 of the judgment. They can summon any person, record their statement. They can also ask for record of any. In fact, if these 3 gentlemen, which Supreme Court in its own wisdom have chosen, summon the National Security Advisor, the Intelligence Bureau Chief, and the Director of Central Bureau of Investigation, NIA, record their statement, then the truth will come out. I'm not saying which way the truth will hit, but truth will always hit someone.
Well, yeah.
And truth is infinitely more powerful than untruth. This Supreme Court judgment has saved India's, sort of democracy. The stature of the Supreme Court has gone up, sort of several fronts. This is not a political debate. This is a debate for the basic structure of Indian Constitution.
Yes,
and
Mr. Bhattacharya, you're right. You're right.
The Supreme Court has risen to its highest stature.
Although I am one of those people who believes that, for me, Supreme Court is always up there, irrespective of whether their orders that come in one case or the other is something that would be something that I agree or disagree with. The Supreme Court has always, forever kept, right to privacy, fundamental rights of people, including press freedom, right there on top. It is for the other institutions to get the message, to follow and to implement those and to execute those when it comes to the government itself. Raghav Avasthi, good evening to you. But this makes it very clear. How else do you read a decision by the court where they are not even willing to accept a government's last-ditch effort to say, we will form a committee and probe? They say, no, we shall, because that's how important this issue is. And what you told us was so vague that we can't really now expect you to do a job. Yes, what Mr. Bhattacharya, let me just take it across to Raghav Avasthi.
Mr. Bhattacharya, please let me talk now.
Yes, Raghav Avasthi.
Yeah, you've been speaking for so long. Let me talk now.
The Union of India gave...
So I've read the judgment too. Like Mr. Bhattacharya has read the judgment, I've also read the judgment. As far as I'm concerned, the Supreme Court has been very clear in saying that while the right to privacy is of course paramount, the right to privacy has to be balanced by national security considerations. It has to be balanced with national security considerations rather. So nowhere does it say that national security considerations are less important. If you cherry pick one paragraph from here or there, then that's not, to my mind, in my humble opinion, that's not how you read a judgment. The Supreme Court, the government of India had also offered in its affidavit, while saying that there is so much that cannot be disclosed before the court, and of course anything that is disclosed before the court has to be in public domain because there are national security considerations involved. It was always willing to form an independent committee to investigate. The Supreme Court has gone one step ahead, and the Supreme Court has said that the committee would be formed by them. So this is the only point of divergence between the government and the Supreme Court. The second thing is that the Supreme Court has very clearly said that it does not intend to wade into the political thicket. I think these are the words that the judgment employs. So they have said that they don't want to get into the politics of it. There are some people who will try and play politics who find it very difficult to win elections. So they are trying to trip the government through Pegasus. And I think I heard somebody else also who was saying that the consequences would be serious or something like that. This thought is something that they should really get out of their heads. Mr. Modi is here till 2024. As long as the public supports him, as long as he wins elections, he will be there. There is no tyranny of the unelected in this country. No democratically elected government.
Okay, Raghav, before you go on to that, down that road, let me just bring you back to what we are talking about. And you say you are right if you compare it. Mr. Bhattacharya, if you just give me a couple of minutes, I'm coming back to you. We couldn't hear you properly. I think that I am coming back to you. But Raghav Avasthi, let's be very clear. I think this issue was the biggest talking point in the country for weeks together. Government at various places on various platforms, not just TV debates, but including TV debates, but also in the parliament, in numerous press conferences, sometimes in other events, has very clearly come out and said, we don't take these claims seriously at all. It's only when the Supreme Court started asking questions that the government said, okay, we will set up a committee, and then the court turned around and said, no, now we will look into the issue because your responses are so vague, because no clear stand taken by the Union of India regarding actions taken by it. Obviously, no clear stand taken because Union of India hasn't taken any action. So what stand are they going to take? It is now out there written in the Supreme Court's order. Today, we must have the humility, Raghav Avasthi, to admit that all of the grandstanding that many did to dismiss the claims should admit that it was not right to dismiss the claims. There may not be, at the end of the day, any merit to these claims, but you have to investigate to find that out.
Let me speak, please.
Yes.
Let me speak, yes, thank you. I frankly don't share your opinion that it was the biggest talking point in the country at any point in time. The people of this country are really concerned about their basic necessities. The second thing that they're concerned about is that some of their fellow citizens are bursting crackers when Pakistan wins a cricket match. So I think they are really worried about national security considerations. So that is one thing. I don't think this has ever been the #1 talking point in the country, except, of course, all of us live in an ivory tower. We do these TV debates, so we think that whatever we are talking about is what the common people are talking about. Most people in this country are poor, and they don't really care about whether anti-national journalists are being put under surveillance in a constitutional manner or not.
But the government should care. The people may or may not care. The government should care, because whether they are pro-government or anti-government, they are still citizens of this country, and it is the duty of the citizens of this of the government to look out for all citizens. Now, I'll go one by one. Allow me to go one by one. Everybody wants to make a point.
Inimical to our country's national security interests.
I have seen everybody wants to make a point. I'll come one by one to everybody. Mr. Bhattacharya, to you first, and then Mr. Sapul. Yes, go ahead, please.
You're asking me, Tanvi, something?
Yes, you wanted to make a point. We couldn't hear you at that time. Go ahead, please. Finish it. Finish your point.
Oh, you could not hear me. I made so many points. You know, the question for consideration before your distinguished audience is that today Supreme Court has basically declined to enter into any political thicket, #1.
Yes.
It has played completely neutral and independent and impartial. And it has, in fact, tried to enforce the fundamental right of the privacy to the hilt. And central government has received a stinging criticism for its refusal to even file a proper affidavit. It has filed a half-hearted affidavit, giving the impression that it has something to hide. Now, this is the failure of the, team which was filing affidavit in the Supreme Court. If I may say so, if Supreme Court if Union of India had played fair and disclosed all cards to the Supreme Court, today Union of India have gone out with flying colors. But today, virtually it is in the dock, because it has given the impression to the Supreme Court that it has something to hide. Now, it may have something to hide, it may not have something to hide. This is the bogey of national security. The Supreme Court has held this bugbear.
Yes.
Will not basically, constrain Supreme Court for all times to come in every circumstances. National security is something by merely use this nomenclature and word without any supporting affidavit and all. will made no absolute to arrive at the truth. It has given all the powers to the three-member committee
Yes.
to
Mr.
summon
Bhattacharya,
anybody.
you know, and I want to come to that point in just a bit of how this committee can function and who all can they summon, because they're very high profile, names that were also there. There'll be governments who will have to be asked questions, ministers sitting in the governments in their departments. I'll come to that part in just a bit. But if you allow me to go back to something that you said, and I want to read out from the judgment yet again.
Madam, high profile or low profile. Be you ever so high, law is above
No,
you.
that's not the point, Mr. Bhattacharya. The point is that a police officer in a small police station may not have been able to summon union ministers and chief ministers, but here they can do that. And I want to highlight where the court actually says...
You are not allowing me to speak.
Mr. Bhattacharya, if you may allow me to just come in and with a few more points and go to the other panelists, I will definitely come back to you.
One point, you kindly respectfully hear me out. Para 62. Kindly read para 62, the terms of reference to this committee.
I have.
They can take statement of any person.
But I would want the experts.
That includes the National Security Advisor.
Yes,
that
of course.
Includes the IB chief. That includes the raw chief. Now, whether this three-member committee will exercise the power which the Supreme Court has given, that remains to be seen.
Yes. Okay, absolutely.
And if the power is exercised, Tanvi,
Mr. Bhattacharya, you will have to, I urge you, allow me to come in such that I can give some time to other participants also. And I want to come in here. Gurdeep Sappal wanted to say something earlier. Yes, go ahead and respond to what Raghav Awasthi was saying.
Yes, thank you, Tanvi.
Mr. Bhattacharya, do allow other panelists to speak, please. I respectfully ask you to do that. Yes.
I was carefully listening to what Mr. Awasthi said about right to privacy. Mr. Awasthi, this judgment is a 63-para judgment, out of which 17 paras have been dedicated to discussion on right to privacy. Please do not try to dismiss it in one line. And what is the conclusion? The conclusion is the court says the right to privacy is directly infringed when there is surveillance or spying done on an individual either by the state or by the external agency. This is what court said in the final paragraph, and then said in its observations, the right to privacy and freedom of speech are alleged to be impacted, which needs to be examined. The court is very clear that there is an infringement of right to privacy, which it needs to examine, which it has authorized a committee to examine. Number two, the way you are saying, you are dismissing all the fundamental rights because for you only polemics matter. Whatever BJP says, because of its politics, you are a ruling party. You are a ruling party in this country. BJP is entrusted to safeguard the fundamental rights of citizens of India. The government, it is the duty of government of India. It is the duty of government of India to see to it that the fundamental rights of citizens are safeguarded in letter and spirit and not sacrificed at the altar of polemics. You are trying to say that for BJP nothing matters, no constitution matters, no fundamental right matters, Supreme Court observations don't matter. Only thing that matters is what suits the politics of hatred and divisiveness. This is what are you arguing? Please tell me this.
Okay, let him respond to you. Let him respond to you. Yes, Raghav.
Yeah, can I come in? Mr. Sappal, I have also read the judgment, and you are a very senior person, so I am not going to say that you have not read it correctly. Having said that, the meaning that I have gleaned from the judgment is at slight variance from how you interpret the judgment. Nobody is saying that the right to privacy or the right to freedom of speech are not important. Having said that, the Supreme Court has nowhere said that people cannot be put under surveillance under any circumstances, especially in cases where national security is involved. And as you know, the national security environment has deteriorated over the past few months, especially after the Taliban takeover in Afghanistan and this discovery that there are Pakistani sleeper cells in our midst.
So hence, we should find out who's using Pegasus, no, Raghav?
We also have to balance them.
But shouldn't we not find out who's using Pegasus against us then?
Life, whereby every citizen of the country, or not even citizens, even aliens are entitled to live in peace and not be blown to bits in bomb blasts, which
I don't know what the connection is, but since you raised the issue of national security,
all the rights
Raghav,
have to be balanced. One right cannot be given primacy over the other. Let me
Here is-
complete. The Supreme Court has nowhere made any finding because there was no material place before it. The committee will do its job.
Of
Let
course.
us not preempt the committee.
So nobody's sitting
We
here
should
and
not
saying that
preempt the committee. If we
nobody's sitting here and
what
saying that the
committee
union
is
government
about
was
to do,
spying on us.
then we would be in contempt,
Nobody
sir.
was
I'm sorry.
sitting here and saying that the
Tanvi,
union
can I
government
comment
is
now?
spying on us. We are saying that the union government did not bother to find out who is spying
No,
on
this
us
is what
and
I-
said
this
those
is the
allegations are baseless. And
Tanvi,
now the
can I
court
comment
says,
now?
no, we must find out. It's plain and simple. The union government, when asked by the Supreme Court, what have you done, said national security,
Even the union
cannot
wanted
speak,
us to
can't
find
say
out.
anything. Now, the
Even
court
union
says...
government wanted us to
The
find
court
out.
says the respondent
when
Union
did the
of
government
India has
officially
justified
comment
its
on
non... Allow me to speak, please. At least on this show, allow me to speak. Respondent Union of India has justified its non-submission of a detailed counter affidavit by citing security concerns. It is a settled position of law that in matters pertaining to national security, the scope of judicial review is limited. However, this does not mean that the state gets a free pass every time the spectre of national security is raised. National security cannot be the bugbear that the judiciary shies away from. And Ms. Napanna, I want to come to you back on this. You know, for long we've had the debate over national security and if this must just be left to the government and to the scope with which the judiciary can enter the spaces. Supreme Court today says you don't get a free pass, you must justify this argument.
Absolutely, Tanvi, and thank you so much for circling back to me. I was kind of putting up my finger with respect to what Mr. Awasthi was saying, precisely for this reason, that we are kind of like, you know, when you start talking in terms of fear-mongering, then you tend to forget that you're actually talking about the protection of your own rights. So when we are talking about privacy, we are talking about the rights that accrue to every single one of us in this debate as individuals. So let's not forget that whatever we are speaking about here ultimately circles back to us in terms of what is the impact in terms of the protection of our rights. I have been the most vocal to also put down any kind of aspersions against the government or India as a nation or its ability to protect the privacy of its citizens, etc., when it was just speculation. But when it comes to brass tacks, and this is where we stand, and Mr. Awasthi, I was the one who said the consequences would be serious. But please understand that that was not a political statement. It's a legal statement. In law, if there has been a violation of due process, there are consequences. You have to meet the outcome when you violate due process. And the reason for that is we are a democracy, and a democracy presupposes that the rule of law will prevail. So it is not about politics, it's about law. And therefore, please do not mix the two. Again, when it comes to national security and privacy, it is not about playing one against the other. It is about when does one right supersede the other. So in this instance, the distinction that comes from the Supreme Court's judgment is that when you have a specific concern before you with respect to individuals claiming violation, and I'm using the word claiming or alleging, if you would prefer an even stronger word, because even till date, my stand again is that all of these remain to be proven. My stand very clearly, which is stated in the article, so I put it in writing, is that merely because there are accusations before the government against the government, merely because the Supreme Court is, I have used the word inevitable, that it is inevitable that they will appoint a committee, does not take away the duty or the onus of the petitioners who are claiming violation of their rights. They would still have to prove that. So all of these are matter of evidence. It will have to go through its inquiry or investigation process. Today, the limited issue before us is, was it incumbent for the government to take a definitive stand in terms of its usage? Could it have, set up a committee earlier itself, because it clearly needed to show concern over violation of privacy of individuals, whoever they may have been, because if you're claiming that they are anti-nationals, then the only way you could have put them under surveillance is through due process. And if it has been done through due process, then there would have been no cause for this debate at all.
Yes.
So therefore, today where we are is, one, nobody is making accusations against
Can I
the
come
government.
in, please?
Yes.
There are many
after I
conjectures and surmises in what Ms. Napana is saying.
Not at
Please.
all. Not
Can
at
I
all.
come
Let
in?
me please complete. To
If she's
conclude
done, then
what
I
I'm
would
trying
like to
say,
come in.
sum up, all that we are saying
All
today
right.
is the committee was necessitated. The committee could have been appointed by the government earlier. It didn't. It asked for leave to do so after the matter came up. That was not permitted. The committee has been appointed now. It will be looking into it. And if there are breaches or violations, what I've said earlier stands. I stand by the ground with that the consequences will be serious in terms of a legal outcome.
Yes.
I'm not here to speak about politics.
Yes, and I'd rather not get into it right now as well, because for me, at the end of the day, right to privacy and the freedom of press are important. No, Raghav Avasthi, you will have to wait a little bit more for that.
Can I come in?
No, you can't. No, you can't. That's exactly what I'm saying. There are other panelists who've been waiting for their turn. Allow them, please. Mr. Cheema has been wanting to make a point. Allow him to come in, please.
No, but this diatribe was directed at me. That's why I want
No,
to
it wasn't. No, she wasn't at all. She was merely reiterating what she's already penned down much before she had this conversation with you, Raghav. It's not towards you. Don't take everything personally. It's okay. Yes, Mr. Cheema.
I think, in fact, the important thing we need to remember is this is just the start of work right now. It is the important part is what needs to be done. We need to stop this sort of like snapping at each other, these sort of shots that are being taken, and look at what the situation is. The situation is it's taken months for the Supreme Court to basically force through a committee of inquiry to go into this scandal. And remember, actually, this has been pending since 2019. That's when allegations were first raised in India. And the Supreme Court's order also talks about the fact that, in effect, Indian citizens don't have remedy when it comes to cyber attacks and cybersecurity concerns. We have a larger structural issue here that we need to address. And I think that's the important point. It's not just about the court. It's not just about the courts committee, which will do a lot of work there. Ultimately, we do need a situation where this government takes a clear position to say we recognize that there is a surveillance impunity problem in India. It's not a political issue, whether Congress or BJP, state party or center. We need fixes there. India is the only major democracy where interception orders are issued not by judges, these reports are not made available to Parliament. You don't have independent institutions. India is, in fact, in a time warp. India is what the United Kingdom was in the 1960s, and even worse, because in the 1960s and 70s, when there were allegations of illegal wiretapping and targeting of members of Parliament there, the Prime Minister in the United Kingdom actually came to the House and said, here is the position, here is my commitment here. Here's what we require. So what we require is a clear statement from the Prime Minister on this. We need urgent remedy and reform. The government's own advisor on data protection actually said that the government is not taking steps to combat illegal surveillance. We are going into a surveillance state. Urgent steps need to be taken. So besides the committee and the court, for which a lot of work is left, let's remember that we have a larger problem in India, which whether you're left or right, Congress or BJP, needs fixing. We need to stop
because everybody can use it.
Change.
Irrespective of which government, state, party is in power and which ideology, or and maybe some big entity, corporate entity with that kind of money can use it, which is why it's very, very serious. Mr. Cheema, very quickly though, for a layman to understand what you just said, in the earlier days, it was phone tapping, present your legal case of why you need to look into this person's phone records, put a tap on it and listen to them for 5 days, 10 days, whatever, and get out of it. Do we have exhaustive legal framework that allows spywares like Pegasus to be used, which is once in your phone is actually looking at every part of your life, listening and perhaps even planting things in your phone?
No, we don't. And in fact, Ms. Napanai spoke to this a bit earlier, and I just want to expand on it. She flagged that even under India's current legal framework governing interception, the use of hacking powers to intrude upon a device to conduct the criminal act of hacking of device would be illegal. It's not something that's exempted for. There's no exemption for government or for the government to use a third party to conduct this, whether you're the center or the states. But more importantly also, Tanvi, the legal framework for interception and surveillance in this country is woefully out of date.
Yes.
Multiple government advisors from the time of the UPA, when the UPA's Attorney General, it was leaked in the press, said publicly that, said privately that the legal framework for interception needed to be changed. This
Yes.
idea that a civil servant, a babu, approves it and is subjected to further babu review later, that's not sufficient. It's an insufficient check. It doesn't work, has been recognized across the spectrum for the last 15 years, but we've seen no actual change. And when the government's own advisor on privacy and data protection, Justice Sri Krishna, spoke to this issue, he's been very candid, saying, when I said the government needs to fix this as well, they have chosen not to go ahead with this.
Right.
They have chosen
Okay.
not to create a system where judges and MPs perhaps are overseeing this process or monitoring it. India is the only major democracy where a babu authorizes interception, a babu reviews it, and also it's the only democracy where categorically the use of hacking powers is illegal, and the police and the civil servants know this.
Yes, Mr. Raman Malik, should we not look at this? I personally hope that when the Supreme Court appointed committee looks into the Pegasus issue, there is also a larger path that they lay out for this kind of a legal framework.
Tanvi, first of all, I must put my serious, I have a problem the way you handled the debate and you killed my freedom of expression. I have serious grievances with you. Now, there are 6 or 7 main points which have been put in the last half an hour, and I wanted to respond to them, but you did not let me do so. And I will take this opportunity to do whether you kill my voice or you do not.
I do have only 2 minutes
First
left
of
on the
all,
show, and partial blame
so
goes
let
for
me
that
just
goes to
do not
Raghav Avasthi.
interject.
But go ahead,
Please
Mr.
do not
Raman Malik.
interject. Please do not disturb the flow. First of all, you must remember a senior lawyer from the Congress had said about the interface between WhatsApp, and later the same lawyer went to the court stating the WhatsApp is so secure that these intercepts cannot happen. We must not also forget the same Congress and the same bunch of people wanted to impeach a sitting Chief Justice of the Honorable Supreme Court. We must not forget the way certain sections carried out just now the story of Muhammad Shami, which was basically orchestrated from somewhere else. We must not even, forget the statement made by one of your panelists stating that today it is an impartial judgment by the Supreme Court. Do you intend to say the Supreme Court has been passing partial judgments? And not just that, the 3-member committee, the doubts have been raised on that also, just in your debate, stating that whether they exercise. So you intend to say you already casting aspersions on these people? You cast aspersion on the government, that is another thing.
Okay.
Because of your vendetta and because of whatever. Now let me complete. Now, last point is, those who are using Google services across the globe, your data is secured, your movements are secured, your informations are secured. There are a lot of questions.
But Mr. Raman Malik, it isn't secured, and that's a completely different battle. That's problematic as well for all of these, and there also the government's responsibility comes into bring in a framework at least. But the biggest problem is when the government starts spying, and if there are grave allegations that this is a possibility, whether it's in domestic government or an international government, then there needs to be an investigation. A big thank you to all of the panelists who've joined us, completely out of time. But here is what I want to simply put across to our viewers. From day one, we said we need to investigate this. From day one, we said there is absolutely no evidence that the spying entity was the government. But there are very, very serious claims and a target list of people, names being added and removed, timed to specific developments and events, big events, and which is why it is necessary to safeguard the privacy of people, to uphold press freedom, that the government finds out what really happened. The government outright from day one dismissed it, not even taking it seriously. I just want to leave you with what the court actually had to say and why they finally came in and ordered a committee. This court gave ample time to the center to disclose all information regarding Pegasus attacks since 2019 when the first report came out. However, only a limited affidavit was filed, throwing no light. If the respondent had made it stand clear, it would have been helpful. The Supreme Court was forced to step in and order an investigation via this committee because the government won't. Now we hope that the truth comes out soon. We wait to know what really happened. if there is merit to these allegations of illegal surveillance. Thank you for joining us.